speak briefly to the members that are on the phone once we're on. So work session was requested based on a meeting requested by the municipal attorney, title being role of municipal attorney. Can you hear online?
Yes, we can hear you.
Okay, thank you. Sorry. So, starting again, work session regarding role of municipal attorney in assembly council's office, presentation on balance of powers, conflict evaluation on a Clutna matter, and discussion of ombudsman ordinance pending litigation and indemnification and questions. So initially it was requested that there be a special meeting. A special meeting was not authorized for the purposes of this, but a work session made perfect sense. So we agreed to host the work session. We provided a date because we were told it needed to happen before the 5th because the municipal attorney would be traveling, and that date wasn't going to work for the municipal attorney. So we proposed the next day, this day, on our regular schedule of work sessions, because this is the last day for a work session before we hear public hearing on AO 2024-25, which is the ombudsman ordinance according to the title. So for the purposes of this work session, we will not speak about the role of the municipal attorney per se, but we will focus on the role and the origin of the assembly council's office. We will not be speaking on the presentation on balance of powers or the conflict evaluation on the Clutna matter that was conducted by the municipal attorney's office. And then we will also not discuss pending litigation. And so for the purposes of the order relating to the title, we will be discussing the origin and history and powers of the assembly council's office and the discussion of the ombudsman ordinance AO 2024-25. And that does incorporate discussions of indemnification. So that's the call of the meeting as amended for today's purposes based on constraints that have been applied after we scheduled the meeting. So first, we'll start by doing introductions, starting with Mr. Hurt.
Matthew Hurt, Legislative Counsel to the Assembly.
Randy Sold.
Zach Johnson.
Karen Bronga.
Scott Myers.
Kevin Cross.
Meg Zalatow.
Christopher Constant.
Anna Brawley.
On the phone, we have Member Martinez.
George Martinez, thank you.
Thank you, Mr. Martinez. We also have Mr. Rivera.
Present.
Thank you as well. I have invited Julia Tucker, who was on the phone a minute ago. She might have returned to the computer to watch on YouTube. Julia Tucker was the municipal attorney who served before Dean Gates when these code changes were initially proposed that we'll be discussing today. And also, we have Dee Ennis on the phone, longtime municipal attorney, who is tuning in probably to listen and help on the back end, but is welcome to join the conversation. So with that, we have an ordinance that is kind of one of the causes for this meeting to happen, and that ordinance is AO 2024-25, an ordinance, the Anchorage Municipal Assembly amending Anchorage Municipal Code Chapter 2.60 to update provisions for the Office of the Ombudsman to provide clear authority to investigate complaints within the Ombudsman's jurisdiction as articulated in the Charter. That's the name of the ordinance. That ordinance was introduced at the meeting on, I think it was the 27th of February, to be heard on the meeting of March the 5th. So that this item is on our agenda. Now, the ombudsman is not going to be able to attend until roughly 12 today, maybe 12:10. So we will have the benefit of his participation later in the hour. Also, just a matter of the order, because we have this meeting over the lunch hour, lunch will be provided, should be here probably close to noon. And so that was arranged as soon as the meeting was set. So for the purpose of today's discussion, we'll start with a conversation from Legislative Counsel Matthew Hurt.
Thank you, Mr. Chair. And I apologize that I don't have everything printed just as of yet. More documents will be coming, and I know you get inundated with a lot of information in your positions. So I thank you and beg your indulgence to let me inundate you with a little more. Please feel free to stop me if I use a term or start getting into legal jargon or legalese at any point. The three documents you have in front of you right now, AO 2024-25 is the proposed ordinance, which we will take up later. and then some excerpts from the municipal charter that I hand Xeroxed this morning that are the most applicable to not only the ombudsman, but also to the Assembly Council and the Municipal Attorney's Office. And then AO 2017-40, which is a rather large AO that established a significant amount of the legislative branch staff in code to include not only the Assembly Council's office, as well as the Office of the Ombudsman. So we'll dip into that a little bit during this. Primarily, I'm going to be doing my origin story, which is, usually one of the later movies that they do when they're really trying to mine their material for every dollar, but I'm happy to get to do it and control the narrative this time. If my jokes don't land, I also apologize for that.
You do
Tough
have,
room.
You do have the excuse that your whole plan got scrambled by an IT outage.
Yeah,
for
it's
an hour
true.
and a half,
Yeah,
Just before go time, but the show must go on.
Yeah, no, we're as I said, I was ready to do acoustic law, and we're plugging in right at the last second. So, with that said,
Miss Brawley has a comment.
Let the record reflect that there was laughing because your jokes are funny, at least occasionally. Thanks.
I appreciate that. Thank you. All right, it is now a matter of historical record that I'm funny. I'm going to tell my wife that today. It's a fact. All right, so I will first direct your attention to the excerpts of the municipal charter. If you look at section 406, you will see essentially just one sentence. It says, pursuant to ordinance, the Assembly Council may engage legal counsel, other professional advisors, and staff as it requires in the execution of its duties. I've sent the PDF to the municipal clerk. And if you could send that out to everybody, I would greatly appreciate it. So you'll have a digital copy of the May 3rd excerpt from the Charter Commission's transcripts, which is where they dealt with the municipal attorney and the language governing that. And the reason I've exerted that provision of the transcript is that it really is an overlapping discussion between the provision of charter establishing the municipal attorney, which I have also included, which is on the next page under section 504. When they moved that portion of the charter for final acceptance, it started a discussion about whether or not there should be legal services available to the assembly. Specifically, it argued about what the language would be regarding the municipal attorney's role and whether or not the assembly should have the ability to hire their own legal counsel. To that end, the final language that you see before you went through a lot of different recommendations. Some of the proposals were that the municipal attorney should advise all the departments, and then it went to all branches, and then it finally settled that it should be the entire municipality. And like all constitutions, that language is essentially the result of compromise. The idea being that to the greatest extent possible, the assembly could receive administrative support from the executive. However, it did not want to make the assembly beholden entirely to the executive. And so the ability of the assembly to contract for staff, legal services as they see fit, was a very deliberate choice to give the assembly the option if they needed. And there's even a quote in there where one of the commission members says, hopefully they can get all the legal services they want from the municipal attorney, but they need to have the ability to get their own attorney if they see fit to. So that provision of code, even though it's just pared down to one sentence, like a lot of things lawyers do, there's a lot of blood, sweat, and tears that went into that singular sentence. So based on that provision of charter is the basis for AO 2017-40, which established the Assembly Council's position in code. I want to be clear that just because there are provisions of code establishing the Assembly Council's office and our role in supporting the Assembly and its legislative function, while it establishes our office, there are no real limitations in charter upon the Assembly Council other than to assist you in your legislative function. Legislative function is also a broad term, but it essentially means anything within your powers as the legislative body of the municipality. We're here to assist you in that. And in dealing with several past ordinances, we've had to explore the meaning of legislative function, and legislative function does include the authority to issue subpoenas. There's Supreme Court case law that supports the assertion that like inherent to the legislative function is the ability for you to gather information. So the fact that you are able to issue subpoenas is part of your legislative function. It's not just the nuts and bolts of drafting legislation and passing legislation. It is the equipping you with the information you need to pass that legislation. It is, oh, thank God.
Matthew, before we
Yes.
move, I want to briefly put a little nuance onto what was just presented. By my read, and we didn't have a chance because everything fell apart
Yeah.
to prep this, the actual position of the Assembly Council was created by ordinance in 2002, basically by an ordinance AO 2002-100, which codified the classification of Assembly Council. And so between that time and 2017, the Assembly had hired Assembly Council. In fact, we have one of them on the phone who served in that interim between 2002 and 2017. What the document 2017-40 did was fleshed out the functions of the office in a more specific way. So slight nuance.
Yeah, and I also want to be clear that the reason that the Assembly Council does not appear in code is that in this very long drawn out transcript, the Charter Commission made the decision because there were proposals to, okay, well, do they just contract their own attorney on an ad hoc basis? Like, what does it mean? And they deliberately kept it to the language in charter to provide you the flexibility to, if you just want it to be on a case by case basis, you go out and get an attorney when you see fit and you need to, and you deem it necessary. That's up to the Assembly, or if we establish it in code and create a full-time position, which is what the Assembly chose to do, you have that flexibility as well. So there was a lot of intentional flexibility built into the code, or sorry, the charter, to allow the Assembly to flesh out those abilities more in code. Primarily because my read is that they did not want to necessarily limit the Assembly in any way with strict language in the charter. Another interesting provision is if you go through these discussions, they deliberately address the issue of resolving questions of separations of powers. And that was one of the strongest arguments for keeping your ability to have your own legal counsel in there, because it was very much on their minds that the municipal attorney does serve at the pleasure of the mayor, as they originally drafted it and as they wound up passing it in charter. Therefore, there's even an excerpt, and if I were a little more organized this morning, which I apologize I'm not, I could direct you right to it, where someone even says, like, well, how is any question of separation of powers not going to be resolved in favor of the executive if the municipal attorney serves at the pleasure of the mayor? So it was very much weighing on their minds that the Assembly may need their own legal advice and their own legal counsel in order to fully assert their powers as a separate branch of government. If anybody wants to jump in with any questions at any point,
Sure.
or if you want to defer
First,
to,
on the charter document that was presented, it's top is Anchorage Municipal Charter. It's specifically, the first reference is on page 13, which is the third page of the document. So just so you can draw your eyes to that, it's section 4.06 staff, in which it specifically speaks what Matthew read. Pursuant to the two ordinance, the Assembly may engage such legal counsel, other professional advisors, and staff as it requires in the execution of its legislative function. And then it's on page 15, which is 2 pages later, the section 5.04. Under the executive branch, the municipal attorney, there shall be a municipal attorney appointed by the mayor and confirmed by the assembly that serves at the pleasure of the mayor. The attorney shall advise and assist the municipal government on legal matters. So I just wanted to point very specifically to the page, so it's easy to read and understand. It's not just there. And so, Ms. Alatil, you had a question.
Yeah, so let's just get to the main thing here, which is the tension between the municipal attorney's office and our ability to have counsel. So in all of your research, did anything speak to, other than in separations of powers, that intersection, right? That is the tension we're having right now. We're hearing from the municipal attorney's office. And actually, when I came on the body, it was very much an idea that you could take most issues to the municipal attorney's office. There was a lot of expertise there. And we had Dean, who had tons of expertise, but not enough time. And now what we've found is we have a municipal attorney's office that doesn't have the same expertise necessarily due to attrition and folks leaving. And we have more counsel, you included with Dean, and we've had outside contractors. So can we look backwards at all to clarify the relationship or the intersection of how we would access those offices and when the municipal attorney's office might be shut off to us beyond separation of powers? I hope that's a clear question. I know there's a lot built into that, but I think maybe you get the gist, because it seems to be that's why we're having this conversation.
So first of all, I think to answer your question, how you access the office of the municipal attorney versus the office of the assembly council, the research that I've done in charter and past practices of the municipality was that there really was, in passing legislation or working on projects as a body, there was no limitation or inhibition of assembly members working with the Department of Law. In fact, Dean drafted several significant pieces of legislation for this body when he was working in the municipal attorney's office. So I absolutely want to convey that they are 100% a resource for this body, and they do have a level of expertise and a variety of topics that our office, just by nature of our workload, could not achieve. So they're absolutely a resource. With regard to limitations, it's really there was nothing. No, let me back up. So to that end, I believe the intent of the charter commission was that would essentially be your first, the office of the resource of first resort for the assembly to maximize efficiency. That said, as this assembly has grown more robust and as the workload has increased, the assembly's seen fit to establish an entirely separate office of the assembly council to aid them in legislation. I think that is also entirely within the intent of the charter commission to give you the flexibility to grow legal resources organic to your branch as you see fit, and to perform whatever needs you see fit, again, assisting you within that legislative function.
You have the floor.
Okay, so one follow-up to that is you mentioned explicitly where separation of powers exists was contemplated for us to get our own counsel, and they explicitly didn't want to limit that ability.
Mm-hmm.
Was there any additional conversation or legislative history around where the municipal attorney's office is already representing a department or interest contrary to that of particular, how an assembly member may want to proceed on an issue?
I haven't found anything specifically to address that issue. However, with that level of specificity, I'll phrase it like that. However, where the assembly would see its interests diverging from the executive branch, I think it seemed very apparent that in such a scenario where there would be a conflict of interest between the two branch or a disagreement, the municipal attorney would, as organized under the executive, would default to the executive branch, and the assembly would need its own counsel to provide it legal resources in that situation. I don't think they ever contemplated a scenario where the municipal attorney would have to try and support both branches at the same time in a conflict.
Thank you.
So I have a number of folks in the queue. First, Mr. Cross, then Mr. Salt, then Mr. Brawley. Mr. Cross.
Thank you, Chair. I requested a work session
Right.
regarding this a couple days ago, and I really wanted Ann Hauser in the municipal attorney's office to be here. I mean, I think that's paramount, and I feel like we're just going to have this conversation again. Kind of wish that we had postponed this so that we could have both comments in the room, whether they agree, disagree, or indifferent, because it helps me get a better perspective. And so I do think it's important to note that, she's working on a very important case for the municipality and wish she could be here, but it's, and I guess it's frustrating because this is the second time in a row in less than a week and a half that we've given her last minute notice to be here. And so there's conflicts and there's issues. And yet, it's very important to have her input. That's very frustrating. So my question is regarding legal. So the municipal attorney, Ann Hauser, she's, appointed by the mayor, but we approve her, right?
Mm-hmm.
So she's a municipal employee, kind of like health department. I kind of see it as because it's not because we've turned down municipal employees. Municipal attorneys in the past. Didn't we deny Mario Bird? Didn't Mario Bird get turned down when he came up and he was proposed and the assembly said no? He didn't get confirmed by the assembly. So again, do you have those checks and balances in that position? So we're saying that she works for the executive, but we didn't let the mayor pick his attorney. We said no to Mario Bird and yes to Ann Hauser. So my question is to Matt, you do a great job for us and I love and appreciate you did tremendously, but who do you work for?
So to answer your question, I work for the assembly and just the assembly.
Okay, but Ann also works, she's a municipal employee, so she's kind of like, I see her as just the ping pong ball being smacked around between the assembly and the executive. We may or may not agree with her, but she's there to provide neutral advice. You say it's for the executive, but we approve that, right? Like we didn't approve Mario. So it seems as if to me that scale, and that's what I wanted to have a conversation when I wish Ann was here. It seems as if the scale is really tilted in our favor. We get our own counsel and you could argue the other way. I can see that, but I guess just differentiating those roles and what that looks like. And I guess my other question is, so she's providing comments and she's providing stuff, but you represent the assembly. Has there ever been a case where maybe you're getting comments from municipal attorney on something that's an ordinance before us? And she's saying, hey, this is where I see that might be an issue. And that information isn't shared with the entire assembly.
I have not personally seen I'm trying to remember. I don't remember. I haven't seen any specific scenario where she has provided advice that was limited to the assembly. There have been instances where she has a question on an ordinance or a thing like that, where she has gone through our office to approach the sponsors. However, I've made it clear every time that's happened that she should feel. In fact, it's actually a lot more appropriate for the Department of Law to directly address the sponsor if they have a question, because there shouldn't be I shouldn't have to be a buffer between. But if you have a concern sorry, go ahead.
No, I guess to clarify, and maybe my question wasn't clear enough, because to me, it's like if I'm working on an ordinance,
Right,
and you guys are helping me with it,
right,
but then there's information that comes to the municipal attorney's office that says, hey, here's some issues that you might have. That information should be transparent to all the assembly members who are going to be voting on the ordinance, because it seems to me it's because she, as the municipal attorney's office, they represent the entire municipality. Does that make sense? It seems to me like that's important information before we make a judgment on something.
Okay, so I see what you're saying. And I think that's why the municipal attorney has the position she does at the assembly's meetings, to provide legal advice to the body as a whole. Now, again, just like our legal advice, it's up to the assembly whether or not they take it or heed it. But as the municipal attorney, how they couch their advice, whether it's directly to the sponsor or to the body as a whole, is whether they think it's something that they need to provide to the body as a whole is really something that they exercise at their discretion. And I've seen at assembly meetings several times where Ms. Helzer did speak up and provide objection or identify a legal issue to something that the body was about to vote on. So I don't see, like I said, I haven't seen any way to inhibit it. Now, if there is an issue that we've identified where we are in the assembly is directly in opposition to the administration over it's a legitimate conflict, like the Jurace document that we just sued the municipality over, I think that clearly would have to shift the analysis, because in that case, the municipal attorney would be clearly representing the executive on that particular issue, and the assembly would be a represented party on that specific issue. Being a government attorney is ethically a very complex beast, because you have to, I mean, Dean and I have it easy. Like, we get to just say the assembly's our client, and it's a much more straightforward analysis. But as the municipal attorney's office, who the client is going to shift from issue to issue. And there could be very specific issues where the assembly would not be her client, and it would have to be the executive, because there is a legitimate dispute about separation of powers, or there is a divergence of interests. So it's tough to give a broad general rule that would govern every situation. With the drafting of an ordinance, she can bring her legal objections to the sponsors or to the body if the body's about to act and she feels it merits her legal advice.
So I would add just briefly a little nuance to that there is a difference between when an ordinance is not yet introduced versus when an ordinance is introduced. So when an ordinance hasn't been introduced, it is black and white, in my opinion. Any communication from the municipal attorney should be with the sponsors. And then if the item is introduced, then the communication can happen with anybody because the record is public. But there are very substantive and subtle questions of privilege within that element.
Point of information. Yeah, I'm sorry.
You still have the floor.
Thank you. I appreciate that. And not to cut you off, but the last thing I just wanted, because, Ann sent an email, and I asked for her permission just to read this one paragraph, because this is one thing I thought was really important. She said, some of the things I'd hope to discuss with everyone involves the importance of the functional relationships between our law department and the assembly as a whole, and an individual members and the assembly counsel's office. I'd hope to help clear up what I think are some general misunderstandings of those roles. Importantly, I wanted to reiterate that the assembly members are encouraged to request legal advice and assistance with ordinances from the assembly council, the municipal attorney's office, or both. The municipal attorney believes it is in the best interest of the municipality of Anchorage, and the assembly members know that they have access to multiple sources of legal analysis and information internally as you carry out your important roles as elected officials to the municipality of Anchorage. And it's sad that I'm learning this after the end of 2 years, because when I got on the assembly, I was told if I had any legislative requests, I was to fill out a PDF form and send it to you and Dean. I never realized I had Ann Helzer, I had anybody else at our disposal to help us with stuff to expedite it. And I guess I just thought, so like that clarification would have been fantastic, but thank you so much.
Yeah, and it was easier in the past for assembly members to work with members of the assembly because there were more of them, but it's definitely, they're your asset. And I look forward to when Ms. Helzer is here to make that presentation. Mr. Salt.
Thanks. I guess I'll tie on to Kevin's comment first. Maybe an ordinance wasn't the right way to couch it, but maybe an agreement that the city's about to enter. Mm-hmm. If Ms. Helzer or the municipal attorney office has an opinion, I think the request would be that we all would see that opinion if it's to be shared with the assembly. I think that's what we're after, make sure that her opinions are shared and we see those. But I have just a quick question. In something like that with an agreement where the offices disagree, let's say the assembly attorney and the municipal attorney disagree, who trumps, who takes, who represents the municipality at the end of the day?
So I wouldn't, who represents the municipality at the end of the day is an easy question to answer. That's the municipal attorney. Who trumps is, as I said before, you don't have to take any of our advice. I mean, if the assembly wants to change every instance of the word Anchorage to, the city of Danyang in code, they can do that. And we can advise that you need to do a charter amendment to accomplish something like that. But in theory, yeah, the assembly could, change the code without changing the charter, and then somebody will sue. And you can ignore our advice. That's fine. So I don't want to say that anybody is trumped or bound by the legal advice they receive. I mean, again, under the way the charter is constructed, the power to govern is with the executive and with the legislative, not their staff. So we can provide you advice, we can identify issues, we can make recommendations, but ultimately the wording of an ordinance or, how things are implemented in code is this body's decision. So
So, and then when that disagreement.
Can
reaches a
you
head-
just say it
Sorry.
loud? Because Chris is dealing with the construction.
So,
Thank you.
so when that disagreement reaches a head, we do something like what we're doing on the jurates issue, is where the assembly is basically suing the municipality to find the correct answer or truth.
I mean, yeah, sometimes, yes, the courts are the only mechanism to resolve disputes between the two branches. So, yes, sir.
Thank you. Next, Ms. Brawley.
Yeah, thank you. I have a question, but also just wanted to respond to a couple previous comments. To the point about that the assembly does or doesn't let the mayor pick the attorney, I think that it's helpful to put some nuance on that, because ultimately the mayor is the one who selects candidates to put forward and appoints them, and then we confirm them. So I think there is some nuance there. Certainly, it means there's not unlimited. Yeah, and serves at the pleasure of the mayor, as the chair just pointed out. So it is true that there is a role for both branches. So that's just a minor point. Also, the characterization of the attorney's office as neutral. I don't know that I would say that. I mean, I would, or maybe that's not the right word, because it implies there's some kind of other third party outside of the two branches, right? And so I think maybe, I mean, nonpartisan certainly, right, and not political in the sense that our jobs can be political or are political. But I think neutral implies that there's a mediator or some kind of, and so I don't think that that's the right characterization. So I just wanted to kind of put some nuance there. The other thing that I've, I guess, come to observe here with this job, but I think also with issues like this, is in some ways the legislative function and the idea of having, elected officials working out policy is inherently oppositional. And I think that is true when you're dealing with attorneys as well, right? That I think, we all would want to see. Kind of plan A would be things like, coming to consensus, coming to agreement. We are certainly limited by the Open Meetings Act. We can't just go work it out in the back room, right? But I think there is, to some extent, to the extent that we disagree or that we are all trying to assert what we think is the best policy and get others to vote for it, that is an inherently oppositional stance. And I think that also comes into play with the two branches, right? That they are not ideally oppositional, but that can happen. And so I guess, so getting to my questions, and I acknowledge that we are different. So I'm glad we are looking at our charter and the intent of our specific government. But also I keep thinking about the state level, right? So we have the executive branch and the legislative branch at the state level. Of course, we have the judicial, but I'm going to focus on those two. And this is not getting into the specific policy issues or the specific folks who are serving in those roles right now, but just the branches. Since I've been in Alaska, I remember multiple times where the legislature sues the governor or the governor sues the legislature, whatever it is, on various issues. And then I'm also aware of at the legislature level, they have I looked up the title, the Legislative Affairs Agency. And so that is, I think what I see is the closest equivalent to the staff who serve our branch. They do a lot of different things. They're listed as nonpartisan, which is relevant from the legislature level because they do, folks have D and R and I and all the things after their names, but they do legislative legal services. So they do drafting, they do research, and I've seen a lot of those memos from Leg Legal. They'll say things like, similar to what Mr. Hertz said, it's advising, right? So they can write A legislator can ask for a bill to be drafted. The staff will do it. The staff may say, here's the 15 constitutional questions that you're calling into question, or here's the legal issues that you want to consider. But ultimately, they write those in a memo, and then it goes back to the elected policymakers. So anyway, so I guess my question really is, given that there is that parallel at the state, is that kind of legally relevant to this discussion, even just in a broad sense? Because what I see is at that level, it's very clear that there are those two. They both have legal counsel, essentially. They have a Department of Law and this other department. So anyway, I just wanted to put that on the table and see if that's legally relevant.
So with us being a home rule municipality, normally separation of powers issues are not quite as common at the municipal level because there's a lot of bleed over. It tends to be like the primary body is a council and then the mayor has lesser powers, or they tend to overlap it to an extent. With us being a home rule municipality, we are frequently a lot more analogous to a state government in our separation of powers issues. And I think we very frequently have been looking to the state legislature and their model for ledge services and ledge legal as to, in fact, your staff are currently like brainstorming ways to make more efficient, more better processes. And that's one of the models we've been kind of taking a hard look at, is seeing how they do things. So just from a staffing standpoint and also from a the provision of legal services / who is the client, I think that's a fairly good analogy to make.
Thanks. Yeah, because I didn't want to bring it up if it wasn't, if it
No.
was completely off base. But also just a note too, in the process of creating legislation, the State Department of Law weighs in, and essentially negotiates, from the governor's perspective with sponsors, what that should look like, or with others working on amendments. So I think I've seen, and I know there are some parallels. So I think it is relevant just to keep that in mind. That again, there can be that oppositional or having two different opinions or trying to work out what a policy compromise might be, and that happens at the state level all the time.
Thank you, Mr. Johnson. Back to Ms. Alto.
Thanks. I guess I want to circle back to this idea of advice given to sponsors by the municipal attorney's office, and whether or not that creates an attorney-client relationship, and when that advice then can go public. So I want to use a current example, not getting into what it is, but excuse me. Randy and I are working on excuse me, short-term rental legislation, and it was drafted primarily by the legislative branch. The municipal attorney's office has provided some suggestions and has done so directly to the sponsors and legislative council. I would assume at this point, all of that correspondence is either, gosh, why is that happening? Apparently I should just shut up, is provided under attorney-client privilege or deliberative process privilege, because the item is still in works, the current S1, or it was S1 version. I presume that protection exists and that the advice given in those conversations is protected. Now, when the S1 gets published, like it was Tuesday night, whatever their thoughts are about that final finished version can be advised to the whole assembly. Is that a correct reading on the intersection of that? Because I guess I want clarity to know when my communications are privileged or not, especially as we're tossing out ideas and doing legislative drafting, versus when I can expect those communications to be public and out, right? Because as drafters of legislation, we might propose wild ideas or ideas that the two sets of attorneys may not initially agree on, and then we come to a compromise position. And so can you elucidate a little bit about that? Because it goes back to Mr. Cross's question about when we get full advice from the municipal attorney. And I think Mr. Constance's point that there's a difference between draft legislation and final legislation.
So one, I can't comment on the professional responsibility or guidelines or practices within the municipal attorney's offices. I'm not an attorney for there. I will tell you what reasoning is, and I can give some sort of general advice. So in the Assembly Counsel's office, our default assumption is that every communication we have with the sponsors is privileged. So every time you email a request to us, our assumption is always going to be that it's privileged, which is why you will see us say, am I good to share this with legislative services? Am I good to bounce this off of traffic or whoever the other party is? So that is always our assumption, because generally an attorney-client privilege exists when the client believes there is one. So we assume you're assuming there is one. The best practice for y'all is anytime you want something to be attorney-client privileged in a email or text or anything like that, put in the subject line attorney-client privilege matter, because that makes it abundantly clear to everybody. So if you are intentionally seeking the privilege, always it's good to flag your communications as wanting that privilege. And even if you don't, if you communicate with our office, it is our practice to never share the details of that conversation, the draft project, the underlying work product, any aspect of it with anybody outside of the group.
I guess I can be a bit more nuanced in my
yes.
question based on your thing. Is the insertion of the municipal attorney's office into those conversations, does that in any way waive my privilege? Or, right? Because my privilege, because they're still attorneys, I would hope would extend to my responses and the ongoing communication with the municipal attorney's office, again, until such time as it's finished and published, and then the different advice is given.
Yeah, again, assuming the communications, one, are intended to be privileged on your part and that you're seeking the provision of legal services, legal advice, then yes, I would think that even, a communication like that would be privileged, would be my understanding.
Thank you.
I have myself in the queue, and I'm just going to direct everyone to this Charter Commission meeting minutes document. I've had an opportunity to run through and lift out the things for myself that bring joy to my life. So starting on page 63, Mr. Jaluski, I have a problem in this area. I might have missed something. There's been a lot of conflict between the Assembly and the mayor as to who has the attorney and whose attorney it is. And when we state here very indefinitely that the attorney shall advise and assist all branches, are we including the legislative branch? And the answer, of course, is yes. But if there is a conflict, a legal conflict between the two, the assemblymen, they say, hire their own legal. So then on the next page is a couple of items. That's page 64. I'm looking, hold on. So lines 19 through 22, Mr. Josephson, I go further because I would not want to preclude from hiring an attorney on a regular basis at some point if they wanted to do it, and not just confine it to a specific matter. So there's long discussions about the creation of an office. It's the packet, the thick packet there.
The May 3rd. Sorry, the second packet or provisions pertaining to the ombudsman. So the May 3rd one.
Yeah, I'm
is
reading
the
only from the attorney one.
provisions pertaining to the attorneys.
So again, Mr. Garnett's like line 5 through 19, there's a whole section there. You made a statement where it really, under circumstances of this type of hiring arrangement, the government attorney in the state or municipal is the executive's attorney. Frequently, there will be battles of attorneys' opinions because legislation and the government attorney is going to have to be a Superman of some sort, not to resolve all doubts in favor of the executive when he's telling the assembly what's legal and what's not. So they all the way back then contemplated how in the world is it possible for the municipal attorney not to give advice that says, well, the mayor's right, which we've seen time and time again. And so it goes on. I direct you again now further again, so to page 67. They decided to be pretty general about the language. There a couple of real gems in here though. They contemplated other ways of doing it. Page 69. The attorney will advise and assist all municipal officers in the department and the legislative on request. Go to the assembly. So I really advise folks to read through all this. I'm just going to point you to the sections that really leapt out at me. Yep.
So on 69, can you turn your mic on, please?
before you move from 69, I had highlighted the line 20 through 22. Nowhere did the charter give the assembly the power to hire an attorney, and then point in fact, 304 said that the appointed attorney goes to advise all branches.
Right, but don't stop me there because you have to read it as a whole. These
Yeah,
are
yeah.
conversations. So yes, there was, so your point is they discussed having it limited only to the municipal attorney. They discussed it there. And so as you move through this conversation, when they made the final vote on the language that was in the charter, they definitely decided it was well within our authority to hire or ad hoc contract with attorneys.
Right, I just wanted to point that out.
Yeah, no, it's good. I didn't even see that section. If you want to be in the queue?
Yeah.
So again, everyone, I think, should read through this as we prepare to have conversations with the municipal attorney about the authorities of our council. So then on page 73, Mr. Garnett, I would put in another short section, just saying the assembly may engage additional staff, including legal staff, when it deems necessary, something to that effect. Page 74, we're talking about deleting the section of that language. On to page 78. Amend to add a section numbered stating that the assembly may retain legal counsel, financial advisors, and for bond issues and other staff as it requires in the execution. It's kind of the evolution of the conversation. Mr. Josephson on page 79, 13, line 13, as I had it, the assembly may retain such legal counsel, which is starting to get towards where we land. Moving forward, they talk about what's to stop the assembly from becoming a kind of a too strong a branch of government. And it's a very interesting conversation. On page 83, they talk about what controls exist. And in particular, there are two controls they speak about, lines 17 and 18. There's the political control and the right to veto. And so those are the two checks that exist on the assembly's ability to hire an attorney. They talked about on page 85, making it only temporary power. So the assembly can only temporarily do this, but that was not supported by the membership at the time. They talk again on page 90 about Mr. Parker or Ms. Parker, line 6 through 8. The mayor has the lawyer and they get to some indiscernible language. The mayor's attorney, they get to lean on the mayor's attorney to resolve conflicts between the mayor and the legislative body. That's wasteful government because always the determination will go that it's the mayor's opinion because that person will be fired by the mayor. And in that case, then it's going to always go to court. Then they talk about on page 91, I don't want the ordinance section to have to apply each time they want to hire a financial advisor on a bond issue or other matters. So they were very clear that the permanency is a factor. Talks on page 94, lines 3 through 12. We talk about this all the time. Under the power she's saying and undecipherable and stuff like that, the mayor, if there was a friction between the mayor and the legislative body, you could say they could try to get information for the borough legality, just saying, and they couldn't get it and they wouldn't tell, just wouldn't give them any information. And there has been a problem. We have at length experienced on this body the relative willingness of members of the administrative branch, the executive branch, to provide information only when they saw fit. And in fact, we just had to fight a case to get a record released that was a public record and should have been released that we had to go to court on. And in fact, we're oppositional to the municipal attorney's office in that case. They were representing the mayor who didn't want that record released. And we wanted that record released, and the courts found at least one of the records, both of the records were actually public. One of them was protected by attorney-client privilege, but the other one was released. So we have actual real-world examples of this. And then they even talk about very specifically on page 95, if the assembly abuses and starts setting up an entirely separate department, it's going to be expensive. And if the voters will exercise their control on the legislative body, basically they point out that the real check on this whole theory is the voters. So ultimately, there is a whole lot in this document to read when understanding why the assembly has, by ordinance created in 2002, the classified position assembly council, and in 2017, the very clear guidelines of what the assembly's council role is. So those are my comments before we pivot to the second half of this. But we have still a couple members in the queue, and I'm still hoping the ombudsman arrives before we get to the specific matter of the ordinance that's on the agenda. So Ms. Brawley.
Yeah, thanks. Just briefly, I wanted to also observe, I'm going to read this in more detail for sure, but as I was scrolling or skimming through it, it's also important to keep in mind that the Charter Commission did not exist in a vacuum. It was basically, there was the city of Anchorage, and then there was the greater Anchorage area, borough, whatever it was, that GAB. And so presumably some of the discussion is comparing current governments with what was being proposed. And so they may be referencing, the city council at the time, which has a different legal structure. And then that's similar to state of Alaska Constitution was, there was a territorial government before that. The U.S. Constitution, there was the Articles of Confederation before that. So I think it's important just to remember that probably some of this discussion is comparing different options or different, existing policies that they decided whether to carry forward or to change for various reasons. So that was all. Just wanted to add some context.
Okay. Mr. Hurt, do you have any kind of closing comments on the subject or anything we didn't get to that you wanted to brief us on? I know we started to ask questions and take it down various rabbit holes before we switch topics.
No, thank you.
Okay. Any other members? If you're on the phone, just unmute and say you want, because Chris stepped out for a minute. Okay, great. And I think Chris is wanting to stall for the ombudsman, but here we go. So we're going to turn to a discussion of AO 2024-25, an ordinance of the Anchorage Municipal Assembly amending Anchorage Municipal Code, Chapter 2.60 to update provisions of the Office of the Ombudsman to provide clear authority to investigate complaints within the Ombudsman's jurisdiction as articulated in the charter. I think this is before us on Tuesday, March 5th. And I think to kick off this conversation, perhaps either the sponsor or Assembly Counsel can tell us the gist of it.
I did, but I had to go to the bathroom, so I lost my chance. So
I said the
Here we are.
or Matthew.
So I'll start, and then I'll hand it off to Matthew. So the ordinance before us is a clarification on certain powers of the ombudsman and establishes a clear indemnification for the ombudsman. So I'm sorry he is not here at this time to speak on his own behalf, but he'll be here as soon as he can sometime in the next 20 or so minutes. So I'll speak briefly to the specific changes in the ordinance. So we, at the very top of page 2, we define more clearly an administrative act. An administrative act means an action, omission, decision, recommendation, practice, policy, or procedure done or adopted by an agent of the municipality on its behalf within the scope of employment or under the apparent authority of a municipal body, office, or individual. That's just making it super clear that an administrative act is either by an agent of the municipality, an employee of the municipality, or somebody who appears to be under the authority of a municipal body, office, or individual. Next, jurisdiction, we clarify that the jurisdiction of the ombudsman, because somehow agents is being defined separately from employees, as we add the term specifically that employees are included. The ombudsman may investigate the administrative acts of employees and agents of the municipality. Next, we go on to clarify in section C, an appropriate subject for investigation by the ombudsman is an administrative act which the ombudsman has reason to believe might be, and we add an abuse of authority into that section. And we also add an item, an item that number 8 is a matter of public concern, which has failed to be or could not be addressed by other means. That just means if no one's picking it up, he has the authority if he chooses or she to do that. Next page, the decline of jurisdiction. This one is very interesting. It moves, if you go to page 4 and look at lines 20 and 21, it removes the section under that page and moves it to the previous section. So it goes from part B to part A. Part A is written in the ombudsman may decline review and investigation. So it adds, the matter has been brought to the courts for resolution or is subject of criminal investigation or prosecution, and the ombudsman determines the investigation is not in the best interest of the municipality. Therefore, the ombudsman may decline to review or investigate. In conversations with the ombudsman, when the 2017 ordinance passed that you have here, that section was supposed to go in this section A, but somehow it was accidentally drafted into section B. Section B being a section that says the ombudsman shall decline review if the matter has been brought to the courts for resolution or is in litigation. Now, why this is important to the ombudsman is when there are matters alleged against the police department, for example, and the matter is going through some formal investigation and legal proceedings, the ombudsman doesn't want to insert the office into an actual investigation going through the courts or through that process. And so there are some very specific reasons why the ombudsman may, in their own opinion, not pick up a matter that may be in a court process or subject to litigation. So that moves it to where he believes it should be. And then finally, we go to the next page, and it states under grievances against the ombudsman, section F, to the fullest extent provided by state law, civil action for damages may not be brought against the municipality. It adds a municipality ombudsman or other member of the ombudsman staff. We just added that section pretty recently. And then we're some clarification there. And then G, notwithstanding section 1.50.010, the municipality shall defend, indemnify, and hold harmless the ombudsman and the ombudsman staff in an individual capacity against any claim filed in a civil or administrative action based on any conduct, act, or omission of the ombudsman's office. The municipality may only decline indemnification of the ombudsman upon concurrence of both the risk manager and the assembly council. Now, for my part, there are two substantive matters happening here. One is the clarification of the shall and may relating to investigations that are subject to litigation. And then the second one is this final piece here that is the ombudsman's indemnification. And that's where this wraps into the conversation about the separation of powers and the ability to hire attorneys and who represents whom. Because in this case, currently, and this is for the entire branch, any indemnification decision is made by the risk manager, who is an executive branch employee, at the recommendation of the municipal attorney, who is also serving at the pleasure of the mayor. This creates a fundamental conflict in the separation of powers. And so what we have done here is put by ordinance the assembly council and the risk manager in the position of indemnification questions for the ombudsman specifically, not more broadly than that. And we automatically indemnify the ombudsman because the office must be independent. And the decision of whether or not the ombudsman is indemnified is a position, a process that can be used by the executive branch to attempt to extort effectively an action or a lack of action from the ombudsman's office. We're not going to cover you if you get sued when you do this, because we don't want this thing to happen. And so the two fundamental changes here are those. One is the automatic indemnification subject to revocation by assembly council, mutual agreement of assembly council and risk manager. And one is that the decision whether or not to make a determination or investigation is up to the ombudsman's determination. So anyhow, that's the principle of this ordinance as it stands. Matthew, I kind of took a long effort. Now you, anything to add?
Well, since I've given you a couple of extracts from the charter, I will discuss those just to try and explain why I bothered to kill a few more trees in support of this work session. Reason being, the ombudsman's inclusion in the charter was a very intentional act. The transcript of the Charter Commission's meetings are many, many thousands of pages. They're over 6,000 pages. And there's not one single decisive point where they really hash out everything about the ombudsman, which was interesting to me. It was something that was a continuous thread throughout. So you really have to hunt through all 6,000 pages to find good discussion of what the ombudsman should entail. So the two excerpts that I've pulled for you were probably the most robust discussions I could find. One was from March 27th, 1975, where Mr. Joel DeVore, it's misspelled in here. I would think it's properly spelled D-E-V-O-R-E, but he was the first Citizens Ombudsman of Anchorage, and it's where he's giving testimony to the commission about the role of an ombudsman and giving his opinion as to where it should be located in charter, should it be in charter, because these were all things they were trying to decide. There were several proposals as to whether or not the ombudsman should be independently elected, whether they should be in charter at all. If they are going to be in charter, should they be under the executive? Should they be under the legislative? Like, what's the role from them? Why not just have the assembly establish it in code later? And throughout the Charter Commission minutes, you will see, perhaps not in these excerpts, but in the Uber document, there's a very clear reaction from the public that the ombudsman is important to them. The polling that they did, the public comments that they received were all very supportive of a municipal ombudsman and how important it was to the citizens, or sorry, the residents of Anchorage to have an ombudsman, which is why we have one within our Bill of Rights, the right to an assistance of a municipal ombudsman. That was very much in reaction to the public comment and the public sentiment at the time that the people very much wanted this. And it was very intentional to give them that, or to codify that right in the charter. And then the second thing was to establish it in charter underneath the legislative branch. And Mr. DeVore does speak at length about the value of putting it within the legislative branch. And the term he uses is independent of the executive and protected from the legislative. He really advocated for as insulating the office as much as possible from the executive. And by nature of the assembly, because its power is diffused across multiple members, it's less prone to abuse. Therefore, he argued for a supermajority of the assembly being able to remove the ombudsman. So there's really interesting testimony in that portion. And then the second portion, which I've included, is from a very late meeting in the process on July 8th, where there was actually a report brought forth, which I couldn't get the actual original report, but it recommended, since the decision had been made at that point to locate the ombudsman within the legislative branch, it made the recommendation that the mayor have to confirm, or essentially give the mayor a veto of that, in the same way that the assembly has to confirm executive appointees. The argument that was made was that the ombudsman should be subject to the mayor's confirmation. And it was just interesting watching them kind of work through that process, and they seem to have settled on turning that down because they wanted it as insulated from the executive as possible. That said, that was kind of the logic that was applied to the provision where we would have the ombudsman automatically indemnified by code, and with him only being accepted from that by essentially concurrence of two non-political actors, one from each branch. The idea was that, once again, that would preserve the independence, enabling us to ensure that he was protected and could not be abused by one branch of government acting independently of itself. Because if it was couched all in terms of one branch being able to make that decision, there would be a potential for abuse of that. So that
All right,
was
Matthew, we're going to
potential
dive
switch
into the
for that. Sorry.
conversation. No, that's okay. That's okay.
In my defense, you gave an attorney the floor, so
That's true.
that's on you.
Just one brief question to begin. Is the municipal attorney an executive branch employee?
Yes.
Yes.
The
right.
municipal attorney is an executive of the executive branch.
Yeah,
She's
it's in the
appointed and
section
confirmed
5
by
of the
mayor.
charter. So, okay, clearly from the start. Ms. Bronca.
I just, the part about how if you enter into legal, then you can no longer use the ombudsman. I just was kind of curious as to if someone has gone and made a complaint and then they go to a free legal service to ask for clarification. I think they're told then that the ombudsman can't work with them anymore. I'm just wondering why that is.
So may want to come up since you're here, but you probably don't because you didn't prepare for this. What Daryl and I have discussed, you can if you want, have discussed at length, is initially it was intended in 2017 to be in the may section, not in the shall section. And so it would be up to the ombudsman's determination that they can or cannot continue an investigation if it's put back to where it was initially intended to be. As it is now, it's still, if you read the code section, it's very interesting. It says if the ombudsman makes a determination in writing that an investigation is occurring, he shall not investigate. So it also still empowers the ombudsman to make that call to some degree, but I think it's by operation of law as it stands right now, as opposed to operation of executing decision-making authority. And so I don't know if there's anything to add to that, but the intent is to move it so the ombudsman can make that call themselves.
Yeah, so just to clarify that, it gives the ombudsman the ability to make that determination. When you put something under shall, it means he can't inquire. Under that section, that is.
Thank you.
So, and just one last note from my friend Julie Tucker, who was here and helped to draft that legislation. She's on the line. Is that one reason that they have that in there is to ensure that nobody uses the ombudsman to conduct discovery for their legal cases in relationship to matters that are investigated by the ombudsman. So those records are supposed to be kept separate. Mr. Cross.
Yeah, thank you. So obviously the largest two biggest things here is that we're expanding the ombudsman's powers to investigate beyond administrative into employees. And I guess that's probably why we got to indemnify on the back part. We need to add that because once you start looking and we expand their powers into individual employee investigations, there's a chance that any malfeasance may force a lawsuit. And so you got to protect them. So I have concerns over that expansion. So not completely understanding the ombudsman's office, Matt, is investigating employees, which I see as a department of human resources. Like now I see that we're getting into the human resources department. One, is this a role that's currently being done by the human resources? And two, is any ombudsman's office in the state, do they have the powers to investigate individual employees, or are they limited to administrative acts?
Okay, so one, I have no idea how HR works. That's, again, the assembly is my client, so I got nothing I assume they investigate individual allegations against particular employees, but I have no idea what their systems and processes are. With regard to the characterization that this is expanding his jurisdiction, that was the reason I included these excerpts from the charter. The charter itself actually says the office terms, powers, or sorry, the last sentence, the jurisdiction, power, and duties of the ombudsman include acts and omissions of employees and agents of the school district, as well as employees and agents of the municipality. So it was a deliberate choice in the charter to say that his jurisdiction includes the employees and that the ombudsman's job is not limited to the official acts of agencies. And I think that's where there's some real distinction between us and the state ombudsman's office. And it's not quite as applicable to compare. Well, while there are a lot of analogies that can be drawn, I believe the state statute says the state ombudsman investigates agencies and not actual agents. Whereas the charter here was really clear that it was meant to include the individual acts of employees. And that's kind of how it's always been understood in practice, is that you didn't have to investigate specific policies. It could be the individual acts and abuses of employees, even acting under color of their office. So.
Okay, so then my follow-up question, which is for Tyler Andrews, who's in the back here, HR, which is why I asked him, because I looked at this. And Tyler, if you want to see listening. Anyway, I was going to ask him if he felt as if this either contradicts or complements what HR currently does to investigate employees. Does that make sense? Would that be a more appropriate question for Kent Colhase? Since you're walking up here?
Thank you, Mr. Chair. To Mr. Cross, I'm just going to offer right now that the administration isn't prepared to respond to that question. So thank you. We'd be
That'd be
respond
good. If you
later.
want to email us or something, I'm just kind of interested if this change runs afoul with the HR department or what that looks like, because it sounds to me like now we're at two different departments doing the same thing.
Well,
We will
so
discuss that.
thank you for that. And it also could be that you have, and I'm not saying it's this department at this time, a department not doing anything, at which it leaves an employee or a member of the public concern that isn't being addressed, which we speak about in here. So it's both scenarios. Whether there are two happening or where there should be one and there isn't, there will be another. So yes, that is a fact.
Yeah, just interesting because now what we're doing is we're creating a situation where you may have one individual or one situation being investigated by two different departments, and that would be a lot. Thank you.
So Mr. Salt. Oh, go ahead, May.
I just want to clarify what we do in our office when it comes to a complaint related to HR. Just because someone contacts our office, we don't just start investigating right off the bat. We do have a process that we follow, and through our intake process, we try to find out how far along they are in the process. If we, in our inquiry, find out that they haven't even contacted HR, we would refer them there.
Now, Mr. Salt.
Okay, thank you. Yeah, my experience with the ombudsman's offices in other industries is they're kind of beyond reproach. They're neutral, not weaponized, accountable, but almost accountable to no one. And that's the purpose, so they can field these calls, conduct investigations, go where no one goes, and be a sort of a safe outlet when maybe you're working in an organization that has issues. I guess my question for Matthew is probably Section 4G. That seems like a pretty broad statement. You know, usually there's some qualifiers like any conduct in performance of their duty, any willful omission of the ombudsman's office. So you're protecting them against mistakes and what might occur during performance of their job, but it reads pretty broad that it's almost a get out of jail free card. Is that, am I reading that
Can you
wrong?
point us to the page?
Yeah, it's page 5, section 4, item G, indemnity clause. Yeah.
I'm looking at the wrong ordinance.
Probably line 28 is really the one.
I got it.
So I will concur that it is broad language. I will say that this was, having spoken about the state ombudsman's office, the state ombudsman is actually immunized completely in statute, which was the original inspiration for the subparagraph F above it, which was to the fullest extent of the law. Our municipal ombudsman, and it ties to a state statute that immunizes municipal employees for exercising their discretionary functions. That limiting language of discretionary function is nowhere included in the state ombudsman's statute, where they're just straight out immunized from civil lawsuit. We don't, it's not clear whether we would have the authority to pass similarly broad language completely immunizing the ombudsman at the municipal level. However, it is widely seen at state ombudsman's levels and with state agents that they do have that similar immunization. And the International Order of Ombuds, or Brotherhood of whatever it's called, I apologize, may know off the top of her head, but there is an international organization, kind of like the American Bar Association, but for ombudsman, that has best practices, and that is largely seen as a best practice to provide some sort of immunity only from civil lawsuit. Just to make it clear, like the law still applies to the ombudsman. Like they can still go to jail if they break the law. So there's no get out of jail free cards. But protecting them from civil lawsuit is widely seen as a important protection, and so we were trying to craft language that, to the greatest extent possible, the municipality would use the resources and authority at its level to protect that office from civil lawsuit. So.
Or action or inaction based upon the threat of civil lawsuit.
Yeah, my concern is just, and just for this, I don't know who sponsored this, but Chair, just maybe qualifications around, hey, this is in relation to doing your job. And if you willfully omit, if let's say we have a corrupt ombudsman and they willfully willfully put out omissions, don't do things because it may implicate them, whatever, then they should be no longer indemnified.
And so in the previous version, the plan was just indemnify, period, full stop. And the answer to the problem you present is, if in fact we as a body find that there has been some willful misrepresentation, some action that is outside of the veil of reasonable, we would fire them, and then indemnification would evaporate. And so that was the initial framework, but then we decided to move it a step back, provide the executive branch a seat at the table in the conversation about how to protect the ombudsman and not provide an environment of abuse. And so we did start farther and we brought it back. So next in the queue, I have Ms. Alatil.
Thank you. So I have a comment, and then I want to talk a little bit more about indemnification. I like that the ombudsman can investigate even if there's a court proceeding or otherwise, because I think it's important to realize that the remedies available to the ombudsman are different than the remedies available from other forums. And if you think about what the ombudsman's supposed to do, it's supposed to ultimately improve the functionality of government and can make recommendations to government that like a court wouldn't even make. A court isn't going to necessarily get into our business because it's not related to the legal claim or the process improvement that's possible. So, and I actually, in some ways, don't like that there's discretion there to actually let the ombudsman walk away from something that might be in another forum if it could result in actually good recommendations for government. Back to indemnification, I might be in the very minority view here, but I don't think an indemnification clause is necessary because, and I want to hear counsel's feedback on this, indemnification would attach as long as the ombudsman's acting within the bounds of his or her job. And if you didn't want to indemnify the ombudsman would have to be named individually in a lawsuit.
Mr. Hess, come forward. Sorry.
Would have to be named individually in a lawsuit, and certain criteria would have to be met in order to find that person personally liable. And frankly, there would be a call internally, and I guess maybe this is what this gets to, about whether or not representation on that question. Okay, yes. So it's nuanced there. The indemnification goes to that the assembly council and risk manager would make that call should the ombudsman be named personally about whether or not they were going to provide that legal counsel under MOA resources to get resolution of that in front of a judge.
Yes, and that's
okay.
The cross-reference that's made there with section 150 references the process for all municipal employees, where if they're named individually for something they were done acting in the scope of their employment, the process for the majority of municipal employees is, or all of our municipal employees, is the risk manager makes the decision in consultation with the municipal attorney. And so this is essentially shifting the burden to the default is they will be indemnified no matter what, and then requiring the concurrence of both the assembly council and the risk manager.
And it only applies in the very limited circumstance where there's actually something filed that names the person personally, and then the decision is made whether or not to use municipal resources to get that question
answered. Ma'am.
Thank you.
So I don't know that I have anyone else in the queue. Go ahead, Karen, Ms. Morongo. Oh, I did have you. I'm sorry, I couldn't read the first letter. Mr. Myers, then we'll come back.
Okay. Thank you, Mr. Chair. My question was kind of along the same lines, Mr. Cross, and I'm not sure if I got an answer from Matthew or not, if the state ombudsman has the exact same jurisdiction that we're asking for here. And if not, do any other boroughs or municipalities in the state of Alaska provide that?
So again, I believe, and I'd have to double check, but the state statute limits the jurisdiction of the ombudsman of the state to agencies. However, the jurisdiction of our ombudsman is established in charter. And so the provision where we insert the term employee is really more of like a housekeeping thing to bring unity between the code and the charter so that the language parallels each other. I really don't think that it's more of a grammatical change than actually changing the scope of the ombudsman's jurisdiction. Because it's established in charter as the actions of employees and agents of the municipality. That's really the jurisdiction. The language in the code can't limit that. The charter's jurisdiction is going to take precedent over what we put in code. So I was actually just trying to bring as much symmetry between the language of the code to the language of the charter as possible with that addition. With regard to other municipalities in the state of Alaska, I looked around and I don't believe, and I would have, I don't think any other municipality has the same language. And frankly, I don't think any other municipality has the same establishment and charter of their ombudsman as we do. I wound up looking in Michigan because both Flint and Detroit have their ombudsmans established in their municipal charters. And Detroit actually has every possible provision pertaining to their ombudsman in their charter, which is how important that office is to them, apparently.
And Matthew, I'd add one thing, that it's really important to note that the state ombudsman has broader protections and authorities than our ombudsman does.
Yes.
Because it has been granted to them under powers of the state legislature, which we're a subsidiary of. We can only go as far as powers authorized to us or not specifically excluded. The state ombudsman has more broader effect. So, and I think I can say, without being contradicted, that the ombudsman has in fact always investigated employees if the matter met all of the terms on which the ombudsman may or shall, and then the ombudsman determined to investigate. There has never been a practical limitation on that in the history of the ombudsman's office that I'm aware of. Is that a true statement, Mr. Hess?
Yes, the office for over 45 years has consistently investigated complaints brought to us regarding municipal employees.
So for practical matters, it just, as Mr. Hertz says, brings all the language into alignment to the practices and to the charter so that there can be no question. And I feel like there's a few projects we've had to work on lately that aren't changing the code, or changing what happens, but they're clarifying the process, because you can use language to say one thing, you can use it to say another, and then argue over those things. We're just making it very explicitly clear the powers that exist today.
Okay.
So, Mr. Hess, since you're here, do you want to briefly discuss this ordinance as we have drafted it?
Well, thank you. I appreciate the opportunity. You know, the one section in this ordinance that I think is very, very important is moving the requirement that currently the code states that if the matter has been brought to the attentions of the court or is in litigation, we shall discontinue. That provision was only added to our code in 2017, and we requested the addition, but we wanted it under may decline. So because we have a lot of people who frequently come to us and want to file complaints against the Anchorage Police Department regarding open criminal cases. Obviously, we don't want to get involved with that. And they would question, well, where does it say you don't have to, that you can decline this investigation? So we requested that it be added, but we had wanted it added under may. and not shall. Because what is really problematic for our office is, say you have a former municipal executive who sues the municipality and makes certain allegations. And I think if this is broadly interpreted by the Department of Law, because that one former employee has filed a lawsuit and mentioned certain alleged facts, we cannot assist the 8 or 9 or 10 or 12 other employees who come to us and want us to look into a similar complaint. So I think applying that requirement so narrowly really hinders us to be able to assist members of the public and especially municipal employees. And I have to say, in 12 years as ombudsman, we've never been sued. We've used our discretion over the years to decline certain cases. If somebody files a lawsuit, they come to us, they file a complaint, and then they file a lawsuit against the municipality, we will discontinue that complaint. Or if we believe it's a matter that's appropriate subject for review, we would insert ourselves as the complainant. But we will not continue to investigate a case when the individual has sued the city, or it's an ongoing open criminal complaint, but not allowing us to have some discretion on declining or not declining or discontinuing is going to really hinder our office. This is a very narrow interpretation that's different than what we've dealt with over the last 7 years since this was added to the code. So I think it's interpretation more than anything.
Which is common cause these days. Ms. Zolotel.
Thanks. So I'm actually a little bit worried about that, declining or walking away when a lawsuit is filed, because I think what the ombudsman's scope of investigation is so particular to how government functions and where government can break, not about liability, workplace liability or employment claims or even criminal claims, really. It's really around good governance and good governments. And so if we walk away from those opportunities, what we walk away from is the process improvement that could come from the ombudsman's recommendations. I get the fear and the risk that it could be used for discovery, but the lane of investigation for the ombudsman should just be so different than the lane of discovery. And frankly, discovery, all those things have to run through their own pathways otherwise. So I'm troubled by this, quite frankly, and we're not going to resolve it today. And you're going to probably get discretion in the ordinance, but I guess I want us to think about it more expansively, because, for example, to take it out of your office and take it to the state ombudsman, there was just the report released about dental care in prisons, right?
Yeah.
Let's say while that investigation was pending, the ACLU filed on behalf of inmates. It would have been a real disservice for that ombudsman to have stopped her investigation while that pending litigation was happening, because the process improvements likely won't necessarily come out of that litigation. It will come out of a thorough investigation and report by the ombudsman. So I just want us to think broadly about it, I guess.
So which is the code allows the ombudsman's office to open on our own motion an inquiry if we believe it's an appropriate subject for a review. So in those cases, that's just why we need that discretion, that one, case by case. So if somebody files a complaint and we're looking at it, we're investigating, then they sue the city, we might discontinue the investigation as their being the complainant, but then we could substitute our office as the complainant if we
Okay.
believe it needs to be addressed.
And that's a nice nuance. And I think that's important, because what I was hearing was your practice is just to discontinue.
No, I
Okay.
misspoke on that.
Thank
No,
you.
I recently did that because a former employee filed a lawsuit. So I removed them as the complainant and I substituted our office because I believe the subjects of the investigation were important.
So there's a second half of the ordinance that I also would like to get your opinion on. The second half being the issue relating to indemnification. So what this does effectively is it automatically indemnifies the Office of the Ombudsman, except in the case where there's some extraordinary thing that happened that can't be possibly be in the furtherance of the office, and the determination is made by the risk manager in consultation with the assembly council, and it's automatic indemnification, meaning both parties have to agree that it isn't indemnified in order for the indemnification to lapse. That's the practical process of that second part of this ordinance. Thoughts?
So I would say in 47 years that our offices existed, I'm not aware of any time we were ever sued. We offer opinions, we make recommendations, we try to be fair and reasonable. But I think sometimes our office expresses opinions that may not be popular with certain, officials at the municipality. And I think when you have the risk manager making that decision, they serve at the pleasure of the mayor. I am not questioning the ethics of the risk manager. I know the risk manager. I know the current municipal attorney. I have no concerns about them, but they won't be there forever. So I think having this check and balance is pretty important.
Okay. Anyone else have questions on this? Mr. Cross?
Just out of curiosity, who investigates the assembly?
We cannot.
But like who?
The assembly.
I guess I never asked that.
So people have asked me that lately. And in Alaska, whether it's local government or the legislature or the mayor or the governor, there aren't a lot of options. You have the ethics board if it might involve something, that's covered by the ethics code. We tell people you can start a recall, you can run against them, but there in the state of Alaska, you don't have a lot of options to address concerns involving elected officials.
But I want to make sure you heard what he said. It's the mayor and the assembly are both in the same bucket.
And the school
there,
board.
And the school board. This is not a path available to that. Recall is.
Yeah, because it's in the charter.
Yeah. So that is nothing we can do by ordinance. Other members? Ms. Ronga?
So if I heard you correctly, on page 3, are you saying that you would rather it said the ombuds in section B, the ombudsman may decline?
Yes.
You would like the shall change to may?
Practically what we're doing here is we're moving it from section B, number 9, delete it there and add it under A, and A is the shall section, right?
So we're moving it.
Yeah, I'm sorry, is the may section. So we're moving it into the may, at least in this proposed one. So it achieves what he said, but not by adding the word may in the section that says shall. It's by moving the whole piece to the previous page.
Okay.
That's where they're deleting it, is basically.
And so
Cutting
this,
it here.
so I'm just having a hard time following. So the may, this was the shall section, and when we move it forward, even though it says shall, it becomes may?
Yeah, so
It's
if you
because it's the may
compare-
section.
It won't say shall. It says the ombudsman may decline review and investigation, and then it lists 5.
Oh, okay.
So it's
Okay.
moving it from shall to may. And as I said, when we requested this addition to the code in 2017, that's where we intended it to be placed, but it slipped through.
Okay, thanks. And then my final, on page 5, the G, just kind of in response to what Mr. Soltz said, and maybe the section 1.50.010 covers it, but I kind of wondered if the statement, in an individual capacity against the claim filed, blah, 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 when you get to ombudsman's office, maybe a comma that says, while performing the duties of the position would be a clarifying, you're indemnified, but does indemnify mean it's only when you're doing something at work that's based on your position? I guess I just don't know what indemnification.
I think some people could interpret this very broadly. I think that's a good point.
Yeah, I kind of think it might be a good idea to add comma while performing with legal speak.
So I can briefly speak philosophically. I think it could go either way. It doesn't really matter because these are the official acts of the office being considered not unofficial acts. And that's where the determination would be made by those two individuals. These were clearly not official acts, doesn't fall under the code of what they're supposed to do, right? And so it's already set up that way. It could be made explicit. And again, if in fact Risk and Assembly Council decided it was an official act and it just plainly wasn't, that the Assembly would be empowered to say by 7 members, thank you for your service. Now go visit the court. And so we could fire them. And so ultimately we can add that. I don't think it harms anything to add that. It's, I think, just redundant, but it's fair read that it is only in the conduct of the business of the office. That's how it's intended, for the record.
And that's a good point. If the ombudsman ever goes rogue, the assembly can, with 7 votes, can dismiss them at any time.
And even in this charter document, the discussions were around 6, 7 or 8 votes veto. But the mayor ultimately has a veto, I think, on these matters. And so because of that, it does really take 8 votes to hold an ombudsman in office, or not to hold, to put an ombudsman in office. The removal is only by a majority of the body. And so they didn't go with that higher expressed standard through the charter convention and conversations. Instead, they went with the straight up assembly majority. So it's an important ordinance. It's timely. It's not done in a vacuum. There are people who are listening to us right now who warrant protection. So with that said, any other questions on this matter? Right on time. It is 12:50. We do have lunch in the back room before we kick off our next work session. I think the next work session will be briefer than intended, but thank you, everybody. We'll adjourn this.